the prosecutor's office basically does the same thing. So they have a lot of volume there. You have 4 different courts literally going on. So one of the things that we need to make sure is that we have continuity of service. So you need 2 there. That way, in case a lot of the courts are operating at the same time, they're not waiting for us.
Do you anticipate with the staff that you have that you can continue to maintain it, or you think you're going to have to hire more attorneys?
Well, we are, in the courts that we're in, I staff it based on, there's a few things that you got to look at. You got to look at how many cases each attorney's doing.
Sure.
And there are certain guidelines for that. None of them are mandated, but the ABA, there's the Ohio Public Defenders Commission, there are certain guidelines. That being said, you can only see so many cases at any one time. And if there's only one judge and one prosecutor, we probably won't need to extend any staff. I base it kind of on that. Now, if for some reason they were doing 5 times the load in one court, I don't see how they can do that because there's only so many minutes in a day. We would have to think about that. But I peg it by the courts.
I see.
And if they had 2 Muni courts in Medina, then we'd need to expand.
Sure.
But as of right now, I don't see that.
Now that you touched upon it, Tim, I put this down as one of my questions. An approximation would be fine, but how many clients does your office handle in a year?
Okay, right now, in the Medina Muni Court, we opened up 1,100 cases roughly last year.
1,100 just in Muni? In
Muni. And that basically is all the misdemeanor crimes of 4th degree or higher.
Okay.
To be eligible for the public defender, the criminal charge or any charge has to carry the possibility of a loss of liberty, of jail.
So your services could only be for people that are charged with something that could result in them being jailed.
Going to jail.
By loss of liberty.
Right.
Okay, so for the minor misdemeanor that would carry no jail, but if just simply a fine, then your services are not.
The only time we would get involved with one of those cases is if they had a jailable offense coupled with it.
I see.
So they don't split those up. So if they were charged with assault and minor miss disorderly, we would be on that case. But if it was just a straight minor miss disorderly, no. We don't do traffic tickets.
I see.
But we do.
But that's still a pretty, that sort of surprises me, leaving traffic out and minor misdemeanors, which, small claims, you don't have anything to do with it, but you still have 1,100 just there. When you come over to Wadsworth, about how many are we looking at there?
Well, there's about 500. 1,100 is 2 attorneys. We're doing about 500, between 450 and 500 each attorney.
I see.
At the Muni Court level. And that covers the OVIs, the driving under suspensions, the reckless ops. There's certain traffic offenses
that would put a person in jail.
Right.
I see.
So they're, and that's within the standards of the ABA. For misdemeanors.
Now, when we get over to juvenile, what do our numbers look like there?
Juveniles is less, but they're more time, labor intensive. We opened up, last year in 2009, we opened up 235 cases, I think.
I see.
But juvenile is a quasi-civil nature.
Sure.
The same offense that would be a crime in the adult world, there's a lot more things that go into a juvenile analysis, and they're more labor intensive. Like I said, you have guardian ad litems, and you have the criminal, and you might have the mental health board, your job and family services. So to get all those people together for one hearing, that might take a half hour in Medina Muni is going to take you an hour, hour and a half. So anything, again, if they qualify for our services, and in juvenile court, they're going to qualify a lot easier because they're children.
Sure.
We handle those cases too. We handle felonies in juvenile also. So we handle the whole.
All the way, misdemeanors and felonies. One of the things that happens in juvenile court, I think it's referred to as a status offense. meaning that it's not a crime for maybe people, you and I, like you and I who are adults, but for kids, truancy is the one that comes to mind. You know, we don't go to school anymore, but...
Or alcohol.
Well, there you go.
It's not against the law for a person 21 to drink, but it is.
But someone accused of that type of a status offense, would they be eligible?
Well, as a courtesy to the court, often we'll do the unrulies, that there might be an issue that the magistrates might feel that there's a triable issue or a reason to have.
I see.
So again, it's a lot of a case-by-case basis. There's no real fast rule to it. If they're in juvenile court, there's a good possibility that at the very least they could end up on probation.
Sure.
And that's also a kind of a penalty.
Well,
so that
if you violate, a person violates, they could very well, as you said, lose their freedom.
Often, you might not start with that case, but they might violate a court order, and then they're looking at going to detention center for violating court orders. So sometimes we get them on that end of it.
When the juveniles, the children, are associated with this, Tim, how does the parent come into play? I mean, you or a member of your staff will actually stand next to the juvenile in court. They're your client.
We work for the juvenile.
Okay.
We try, and most of the times it's not an adversarial nature. The parents want to see the best thing for their child.
Sure.
They really do. And but when it all comes down and it's said, our allegiance, and we work for the juvenile, sometimes that's at cross purposes to the parent. Parent has to understand that. There's often the child is more afraid of displeasing the parent than they are the court.
Yeah.
So
I can understand
we
that.
got to let the parents know that for us to really find out the truth, sometimes we got to talk to the kids alone.
Well, I think it's good for our viewers to know that, because I think sometimes we all get affixed as, well, you know, you're not old enough. You're just not old enough. You're not old enough to drink. You're not old enough to buy cigarettes. So somebody may think, well, you're just not old enough to have an attorney. But that's not really true. I mean, you stand with a juvenile, even though a child could be 7 years old, you would be his or her attorney. Tim, before I lose it here, I mean, it's just a little administrative question, but I think the folks would appreciate knowing it, particularly being somewhat new to the scene. Where are you located? Where is your physical office located?
Our main office is at 120 West Washington, and that's in downtown Medina. It's one block off of the square.
Okay.
And
120 West Washington.
120 West Washington.
Right in town there. Well, we all need to know that. That's where you could find Mr. Lutz if you need him. Well, probably following right along, this is a very significant question. To be eligible to be represented by the public defender, what's required, Tim?
Okay. Well, two things are required. Basically, you have to be charged with a crime that carries the potential for jail.
Go to jail.
And the other thing is that you have to be deemed indigent.
What does that mean?
Well, indigent doesn't necessarily mean that you're broke. The state of Ohio has decided they use the poverty statistics that the federal government provides. So as long as you are 120% of the poverty level or less, you can qualify for a public defender.
Oh. So somebody could feasibly have a job and be working, but maybe have a large family, or...
Well, most of our people do work. Right now, the 120% level is $1,100 a month. That's for a single person. You could have a minimum wage job. You could be working at McDonald's, or you could be working part-time. So $1,100 a month for a single person. Then for every dependent you have, your spouse, your children, people living in the household, you can add on roughly $400.